Hello, YouTube. I'm Vince White. I am an employment attorney, and on this channel, we answer publicly posted questions from YouTube users getting focused answers they need from an employment attorney. We have a question here from YouTube user Silence is Golden 337, who asks us, is there a scenario where a jury awards an employee a large amount of money in the sense of punitive damages and so on, and the employee can actually collect that amount? I know there's been juries awarding millions of dollars to employees, but then the judge knocks it down. Wouldn't it be better to have a trial by judge without a jury then? At least that way you get a better chance of collecting the awarded amount if there's an appeal, right? Okay, so essentially two questions here. First thing I'll say is yes, listen, there is certainly large awards of damages that get collected. Please don't misunderstand me. So sometimes big verdicts in this field will be cut down by judges because sometimes juries don't properly follow the jury instructions, don't properly calculate the damages, and they'll get a little wild, and they'll go big with the verdict. Now that happens, and those verdicts often get cut down by judges or get beaten down on appeal, so on and so forth. But please don't misunderstand me. It will always be my preference as a litigator to win a big jury verdict and then play defense on that jury verdict, rather than win a small jury verdict and still end up playing defense on that small jury verdict. If it's small enough that it doesn't matter, then it'll just be paid out. Nobody bothers to fight it. But even a nice round six-figure, $400,000, $500,000 award can still face an appeal. And often those appeals, they may have merit, they may not. They're often meant to delay payment. Right? There's often strategies that defense counsel will use where they think your client needs money in the short term. So hey, listen, we're going to appeal. We feel we have a non-frivolous appeal that we can ethically bring. And it's going to, it could take 2 years for your client to get paid this verdict. Does your client want to accept less in the meantime? And counselor, I'll remind you that you have to offer this deal to your client. You can't hide this deal from your client because you're ethically required to bring settlement offers to your client, right? And I'm like, yeah. I'll let my client know that you are appealing their $500,000 verdict, and you want to offer them a settlement of $200,000. And the bummer is, I do actually have to tell my client that. Not that I would hide it from my clients, anyways, but there's clients who take that. Go like, well, I need $200,000 now. And they often have very sincere and good reasons for that. But it's like, well, what? No, don't. Please, no. We won you $500,000. We think we can actually collect it. We think we can beat this appeal with ease. We'll happily fund the appeal for you. Hold out. Let us collect the money. And they're like, nah, listen, I'd love to, but I got bills and kids and family, and I need the money. Our job, our fiduciary duty is to do what the client wants. So then you do that, right? That is the reality. But to go back to Silence is Golden's question, often you will find that it is more difficult for judges to knock down a punitive damages award, right? If the jury gets activist, the jury gets a little wild with the punitives, the punies, as we say, that is more defensible. And judges are reluctant to touch that because the nature of punitive damages is that there's not a formula. It's discretionary to the fact finder. And here we have the jury. So to get into the second part of your question here, there are certainly situations where a bench trial with a judge is preferable to a jury trial. And situations where a trial in front of an arbitrator, a singular arbitrator, even a panel of arbitrators can be preferable. Often for judges, and arbitrators, you're selecting them when it's a really, really complex legal argument. So for arbitrators, I'll often go with a subject matter expert arbitrator on a case where, a jury might not understand some of what's going on. Hey, my model was just as good as this other guy's model, and it was these investing models, and they're making microsecond investment decisions. But because I was a woman, they chose his model, even though mine was 2% better, right? And can you explain that to a jury? Of course you can. Is it potentially easier to explain it to a subject matter expert arbitrator with a depth of knowledge operating and litigating in a given field? Like this is like a financial, like day trading in private equity model or whatever it is. Yeah. I mean, I think that person's going to understand more, and that person might clue in like, hold on, wait, your model, your algorithm was better by 2%. That's huge, right? A jury might be like, 2% is not that big a deal. 2% over the course of millions of financial transactions really adds up, though. So the arbitrator hears, oh my God, 2% better. That is the sun, the moon, and stars. That is a career launching difference, and the jury might not hear it that way. So you might select the arbitrator, which is subject matter expert. Or like if there's a key legal question that you think a judge might understand better than a jury, you might say, hey, great example, discrimination dealing with African immigrants, African Americans, and Caribbean Americans. That's complex because a lot of juries in a lot of the country say, well, those people all look the same to me. And you can overcome that with education, and you can describe what goes on and how the external pressures that led to these forms of discrimination cropping up and what's going on and the history of it. And you could educate, and you must if you want to win these cases for your clients, right? Because they're very real, right? Like discrimination. If somebody's like, hey, I don't like these African immigrants, well, that's national origin discrimination going on. And also potentially race discrimination going on, even if that person happens to be African American, right? That doesn't change anything. But that can, or vice versa, if the African immigrants are like, oh, we don't hire African Americans because we think they're lazy or something, right? Like that happens too. We hear those cases, but you might want a judge rather than a jury on that one, because the judge will be like, well, yeah, of course, this is how the law is applied. I understand the subtleties of the law more often than not, right? Not every judge. Listen, there's some less than judges in the world. But generally speaking, a judge is going to have a subtle interpretation of the law and a sophisticated one. And there's no guarantee you get a jury that's going to listen to your education of like what's going on here and how this arose and what we're seeing and how we should be interpreting what's going on. If they don't listen, you can talk until you're blue in the face. They're just going to keep on saying, I don't know, they look alike. And that way can lie failure, right? So like you might choose a judge in those scenarios. But generally speaking, most cases, if you're willing to be public with the case, which is a big question, you do want a jury because juries might give you a larger award. There's a lot of statistical evidence to reflect that juries tend to give the largest awards because, listen, juries are not jaded the way attorneys, arbitrators, and judges are, where we all might see a lot of these and have a depth of experience attaching dollar values to cases. And inherently, let's take a moment to acknowledge that's a little bit gross, right? Like, for the fact that I can, in my mind, have thoughts on the dollar value of a sexual assault in the workplace, that's sick. It's my job. My clients expect of me. I must do it, but it's a sick thing to do. It's how do you put a price on that? Like in reality. And I mean, I know the answer because the law provides me the answer, but like, that's the law's answer. That's not the like human condition answer. Like, someone violated the sanctity of your body. Like this is horrible, right? And I'm over here on my end being like, oh yeah, well, okay. So this happened. Forcible touching, sexual assault. Okay. You earned this much. You're treating with a therapist. Okay. There was a retaliation component, so we have punitives in play. Okay. I think this much. That is my job. That is what I must do. That I must make recommendations to my clients, right? But that is a gross thing to do. And it's grosser still because it's me, and I'll be upfront. I've never experienced a sexual assault, and I don't think I will. You know, I'm just not sought after in that sense. And so there's attempts at empathy, but I can't know what it feels like, and so that's gross. And juries, they don't have that depth, like they're not, of experience, right? That nobody's asked them over their career, most likely, to spend a lot of time valuing cases. So they're getting a first sense impression of like, oh my God, this is insane. This I can't believe this was done to another human being. This enrages me. The correct amount of money must be huge. And then, statistically speaking, juries do tend to give, when they tend to give more. And also, the data seems to reflect, at least our personal data, that you would rather win more with a jury and then play defense on that larger verdict to get as much of that as you can collected than win less but have a more defensible position because it's a judge or an arbitrator with a well-reasoned decision, right? I will tell you, though, arbitrator decisions, very, very difficult to appeal. It's a huge advantage to arbitrators that people sleep on. If you get a win from an arbitrator and then the other side's like, well, we're going to go ask a judge to knock this down, good luck. The standard is essentially arbitrary and capricious. Did that arbitrator make an arbitrary decision just based on nothing? And if they wrote a reasoned decision, how are you going to argue they just made an arbitrary decision? The reasoning's there. You might not like the reasoning. You might not agree with the reasoning, but that's not the question. The question was, is there a reasoning? Did the arbitrator have a reasoning for the decision? And if they did, odds are you are not overturning that arbitrator's decision. And so that is a tremendous benefit to arbitrators. Judges are much more subject to appeal in many scenarios than I feel arbitrators are in my experience. Like, if you get out of an arbitration with an award and the other side's like, well, we're going to fight this. Babo, you can say those words, but like, it's an arbitrator's decision. What are you going to do? You're going to say there's not a reasoning, a logic to the decision? I mean, it's a written decision. There's 10 pages of logic. You can not like the logic, but the logic, it's there. I can see it. I'm touching it. It's the ink. It's there, and what are you going to do, Bob? You going to fight this? Yeah. You gonna run that 0.5% chance that you can knock an arbitrator down on a decision with a well-reasoned thought process? Okay, if you want to spend your client's money on that, I mean, sounds kind of frivolous, might seek sanctions against you, but yeah, I guess, if you can go for it. Sure thing, Bob. Good luck. See ya at the sanctions hearing. Don't want to make it personal, but like, you're going to come for my client's money, I'm going to come for you, if I have grounds to do so legitimately, right? So it is what it is. So to answer the second part of your question, where the jury is appropriate, you still want the jury because juries might award more, right? So listen, I guess there's almost like three answers here. Yes, people can defend large awards in employment litigation. Large awards can be defended. You can have 7-figure results. That can happen. It is somewhat rare in the industry, but it certainly happens. And it's not vanishingly small in terms of the group of people who receive 7 figures. 2, punitive damages are more defensible than any other form of damages if we're assuming the jury may not have correctly applied the jury instructions for the economic or the emotional damages, right? It's much easier for them to exercise discretion in the punitive damages because discretion is largely, what do you think? Right? I mean, that's kind of the question in some ways. What do you think? Given the size of this company and given their actions, what do we have to charge them to punish them sufficiently that they don't retaliate in the future, because we can't have them shutting down claims. That's one of the core tenets of this industry. We can't have employers intimidating potential claimants. So we have this component of retaliation with punitive damages. And what do you think, jury? Right? That jury instruction leaves a lot of room. It's a lot of room there. Right? I mean, what do you think? It's quite an invitation to hold forth and give a monetary answer, right? Which is very different from, listen, we've had a lot of testimony about how this person should be able to mitigate in this amount of time, and the economic damages probably are going to be about this much. And the experts disagree whether it's, $800,000 or $400,000, but like the spectrum is somewhere in there, and there's probably not a really big argument for more than that in terms of or in terms of economic damages, because even the expert for the plaintiff says, $800,000. And then the jury's like, 30 mil. Well, we didn't really have testimony to support that, and it's not really in keeping with how the damages are calculated under the law or how the jury instruction laid this out for you, so the judge is going to get involved, right? The punitive damages, it's more, what do you think? We think this much. All right, then it's that much to some extent. Like, it's just much more defensible. And the last part, I think, is trial by a jury where it is appropriate in terms of the context and the many complex decisions you have to make about bringing forward a litigation, where trial by jury is appropriate for your client and for your case, then trial by jury is a better option, statistically speaking, because they do tend, where they give you money, to give more, and playing defense on a large verdict is better than playing defense on a small verdict, right? Anyway, silence is golden 337. I hope this answers your question. I think I went a little long on it, frankly, but there was a lot to say, and I guess I did a little recap. If this was helpful, like, subscribe, comment down below, share the channel so it can grow. Thank you. Take care.